So we'll go ahead and get started. First of all, just with a few introductions. Of course, I want to say thank you to everyone for joining us today. This is a very relevant and needed discussion about the final ruling of Section 1557 of the ACA. So to let you know a little bit more about our team and what's in store for you today, first off, my name is Leah Owens, and I am the Business Development Specialist here at Bromberg. And I also work as the American Sign Language Support Specialist as well. So I've been on both sides of the coin, so to speak, with performing interpreting work and then also working on the business side of things. So we again want to welcome you and thank you all for coming. And it's my pleasure to get to introduce our panelists, Jinny Bromberg and Bruce Adelson. So to let you know a little bit about Jinny, Jinny is our president and founder. She started Bromberg and Associates in 1999, so we're very excited to be celebrating 25 years this year. Under her leadership, Bromberg and Associates has grown to become an award-winning, internationally recognized language and technology solutions company. Bromberg is an ASTM F3130 certified organization, and we cover the entire linguistic and cultural spectrum, working in over 200 spoken and signed languages. And we have a variety of clients around the US and globally. And in this year, 2024, Jinny was named a recipient of the 2024 Enterprising Women of the Year Award. This is a very prestigious award. It's a program that recognizes the world's top women entrepreneurs. And she was also recognized and awarded by NASPO to honor the significant achievements of Bromberg and Associates. So Jinny, we look forward to hearing your valuable input on this vital topic, and in particular, how this impacts language access services. Next, I'd like to introduce Mr. Bruce Adelson. He's our compliance expert, and he's also a former U.S. Department of Justice senior attorney. He's nationally recognized for his federal compliance expertise concerning language access plan, research, and development. During Mr. Adelson's federal career, he has also been responsible for enforcing many federal laws, including the Americans with Disabilities Act, Voting Rights Act, and Title VI of the Civil Rights Act from 1964. With the Department of Justice, Bruce also had responsibility for enforcement and the enactment of federal policy. Professor Adelson, as he is also known, is an instructor at Family Medicine, Georgetown University School of Medicine, and he's also an adjunct professor of law at the University of Pittsburgh School of Law. He teaches implicit bias in healthcare, civil rights, cultural awareness, and organizational culture. So Bruce, we are so honored to benefit from your wealth of knowledge and your expertise, and we look forward to your thoughts and insights. Next, I cannot forget to introduce our amazing interpreters. We have with us Joan Stone and then her teammate, Debbie Crocker. We are pleased to provide this interpreting for any attendees who might be in need of ASL communication services. So we appreciate them being here and working during this webinar today. So as we progress throughout this discussion, please don't hesitate to ask any questions in the Q&A. It could be answered as we progress through the discussion, but if not, we will definitely address it in our allotted time for Q&A. So now we'll turn things over to Jinny to get started. Jinny, you have our attention.
Thank you so much, Leah. I appreciate that. I appreciate the warm introduction and look forward to a productive and engaging conversation with you, Bruce. First, what we're going to do is start a quick poll to gauge what our audience is thinking with regards to Section 1557 final ruling. We'll give it a minute for everyone to be able to answer. You should see it on your screen. Okay, I see some answers coming in. Let's see. Let's give it another few seconds. It looks like majority of people have answered, and we do have a clear winner. So the majority, oh, there are more answers coming in. Okay, thank you. But it still looks like the answer is all of the above. That's the top answer, followed by I'm not sure, that's why I'm here. We appreciate your transparency. All right, I think we can end the poll at this point. Thank you, everybody. And you can see the results. So, Bruce, before we begin, before we dive in, I'd like just to mention how long we have been waiting for the final ruling to come out. Our first webinar on the topic of the upcoming changes to the Section 1557 took place in October of 2022. And now the final ruling is finally here and will be in effect as of July 5th. But it took nearly 2 years. However, it is very, very comprehensive. So Bruce, let me turn it over to you to outline the key updates from the Section 1557 final rule.
Yeah, Jinny, it's funny thinking about that we started talking about this 2 years ago, and we talked about it subsequently, and it was always, well, we're waiting and we're not sure, and there are certain clues about when the rule would be coming out. But yes, the final rule is now official, published in the Federal Register on May 6th. It will become federal law on July 5th. There's a lot here. There's even more than I anticipated and was, somewhat given the heads up about by the proposed rule when it came out 2 years ago. But let's talk generally about some of the big changes, which I think are reflected in the poll. For the first time, policies and procedures are required by law for healthcare, federally subsidized healthcare entities to have. So that has always been recommended, suggested, it's been mandated in certain court cases or federal enforcement actions, but never in a regulation. And now it is. So having policies and procedures that ensure and facilitate compliance with the new rules are now required. There is, as you saw, the requirement for a Section 1557 coordinator. Again, that had been recommended previously. It was in the original rule, but in 2016, but it was not made part of the law. It was just a recommendation. Now it is. The coordinator will have, the name of the coordinator doesn't matter. It could be 1557 coordinator or almost anything else. But that person has significant responsibilities to ensure compliance with several aspects of 1557. Spoken language access, disability access, reasonable modifications for people with disabilities, training, which we'll get to in a few seconds. So the coordinator has a big job. And I think that one kind of short aside about that is, well, who's that going to be? How do you pick the person? Are you going to entrust your compliance to someone who, well, yeah, Bruce knows what he's talking about. Let's just have him do it. How do you train them? And that's an issue that I discovered years ago and have been actively working and involved in training these coordinators so that when something happens, which things happen pretty regularly, they're equipped to know what to do. What's also important, this training requirement includes leadership of healthcare organizations and essentially all employees, especially those who interact with members of the public. One of the more significant changes to me that has not really been talked about in comments that I've seen is that for the first time in law, federal law, the companion or companions of a limited English proficient patient must be given an interpreter. That has never been the law before. It has been recommended, it has been suggested. HHS did that to bring the companion piece on a par with the Americans with Disabilities Act, which has required interpreters, sign language interpreters for companions for decades, 30 years, going back to the origin of the ADA. So that's something new. In addition, there are requirements, just as briefly in a new direction. Patient care support devices or tools cannot discriminate based on protected categories, race, color, language, national origin, never been clearly delineated in law. Now, frankly, and you can tell people that I told you this if you want to, they've always been covered because if they're used in federally subsidized healthcare facilities, any program, service, or activity conducted in a federally subsidized hospital, for example, is covered by Section 1557 and other laws. But questions were raised about, well, it doesn't say that specifically. And from what I understand, HHS has decided, you know what, we'll make it really easy, frankly, for us as the enforcers. Now we did. So we use those specific words in the regulation. That has huge import, especially when you look at various patient support devices and tools being found to be discriminatory for literally for decades, which connects to another new provision, telehealth, covered for the first time in law. They must provide needed requested language assistance. And again, telehealth has always been covered if it's used in a federally subsidized facility. But the HHS got some pushback when they tried to enforce it. Well, no, the word isn't there. It's not covered. It was in 1975, 1982, and 2010, but it's covered now, clearly, unquestionably. So there are a lot of other things too that we can get into, but that's a general overview and really kind of gives you a flavor for the changes, because the changes are very big. Maybe that's why, Jinny, the final rule was like, what, 580 pages? And I have to say, excuse me, I'm still reading it. And when I was looking at it last night, I found some provisions that I had missed before and I didn't know about. So there is a lot there. It's great reading if you're a law nerd like I am, because you find out all kinds of interesting things.
Well, thank you, Bruce. Yes, this is very comprehensive, and I suspect that you're going to keep reading it, and we're going to keep discussing it and sharing it via webinars for months to come, because there will be a lot more to unpack. But let's start with certain provisions that are very substantial. Let's start with what you mentioned first about policies, procedures, and plans. Plan is nothing new, right? We've had language access plan requirement for many years. And I have to say that I've seen a significant uptick in the past couple of years with organizations either developing or updating their language access plans. We've been a part of several initiatives in that regard. And I'm seeing it at the state and federal levels, which is really a great sign. But let's talk about the expansion of this requirement under the new iteration.
That there's been an uptick in interest in plans. I think that's a direct function of federal enforcement, both by my old friends at the Justice Department and HHS, really putting the word out that, hey, this is good. You should have it. We want to see it. So language access plans have always been recommended as a best practice. Sometimes, as you said, Jinny, they're required in court decisions, they're required in compliance agreements with the feds. This time, what HHS did, which is very interesting kind of reading some of these rules in with Fed colored glasses to understand what they're talking about. The policies and procedures must contain the best practices that have been endorsed for decades by the feds that are typically in a language access plan, whether it's how to use an interpreter, how to contact an interpreter, how to do outreach to language minority communities, which is also important with the new rules. So HHS said, well, we don't want to get you confused and say specifically in law, you must have a language access plan, but we really love those plans. They're a best practice. So you know what we think you should do? Your policies and procedures should have the same contents as your language access plan if you had one. If you had one before, keep it. If you did not have it before, get it. But you don't have to call it a language access plan. So that's one of the biggest changes, I think, this specific legal requirement, which will be judged by HHS as far as whether you're in compliance, to have policies and procedures that facilitate and ensure compliance with the new regulations. That has not happened before in this context. So I agree, that is a very significant change. And I know that, it's leaving many to wonder, okay, well, what does that mean? Now, there are a lot of things in the regulations, and we can talk about I'm sure we will talk about the notice requirement, that it's not exactly clear what exactly HHS is asking. But that's something that perhaps we could talk a little bit about. And that's one of the questions I think many people have too.
Well, before we talk about the notice requirements, let's actually do another poll, because I think it would be helpful to see how many people have updated policies, procedures, and plans. So let's ask about it at this point. And again, we'll give it a minute to answer. Oh, I see answers coming in. Thank you. Yes, we're at about 50%. So if you haven't answered yet, please do. This is really beneficial to see where people are. And we'll give it another 10 seconds before closing the poll. Okay. So it's interesting. Yes, and yes, but they need updating are almost at exactly the same level. So that says a lot. And I'm sure with the final ruling, a lot will need to be updated. Even if they were done recently, there is so much that was included in the final ruling that even the best plans will require some updating.
Absolutely. Let's assume 2 years ago, organizations updated their plans relying on HHS's proposal at the time. The proposal is not the same as the final regulations. So unless you've been working nonstop since May 6th, your plans must be updated, because there are new things here that you'll have to address. Some things like the patient care decision support tools that you've never had to address legally. So there is a lot that would need to be added. And I just will give you a brief anecdote from a court decision not too long ago, where a senior vice president testified that we train our staff on the policies and procedures that we have. We do it regularly, and we make sure that our employees are equipped with what they need to know to comply. In this case, it was with the Americans with Disabilities Act and sign language interpreters and Braille documents. Well, it came out through cross-examination that this hospital, which was a very large health system, is a very large health system, didn't have any policies, zero, and no training. So then the VP was asked, well, if you say you train on your policies and procedures and you don't have any policies and procedures, what did you train on? And eventually the vice president on cross-examination had to admit incorrect testimony. She said that, well, yeah, you're right. We don't have any evidence of training. And oh, you're right. We don't have policies and procedures. Not only did they lose the court case, they had DOJ and HHS investigations for, let's just say, a long time, longer than the average time. But that's a great example of what cannot happen now, because policies and procedures were not required then specifically. They are now. So you're in a much different situation. This case was, let's say, 7, 8 years ago. Much different situation than the senior VP was in being uncertain whether they actually had these policies. You have to have, because that's what the law says. And if you don't have them, then compliance review by the feds or enforcement will not look kindly on that.
Absolutely. And it's, in my mind, it's a substantial expansion from language access plans to language access plans, policies, and procedures.
Yeah, absolutely, Jenny. I agree with you. I think that HHS kind of, again, looking at it with Fed-colored glasses, decided we don't want people to get hung up on names. Instead, we want people to focus on best practices, what works, what we've been talking about, frankly, for 20 years, as far as these policies, what they should be and what should be in language access plans. So, which leads me, if I may, can I interject another connection? What a lot of people don't realize, and I include in this leadership of organizations and general counsels, when I've talked to them, many of them don't realize that the Affordable Care Act was built on 6 laws, like Title VI of the 64 Civil Rights Act, the Americans with Disabilities Act. HHS makes it very clear that those laws are still there. And the requirements of those laws may be different, yes, different, than what the Affordable Care Act says. So you have to work to make sure that you have a collaborative compliance, so that if the ADA says one thing and the ACA says something else, you'll have to find that common ground, that happy medium, which is certainly very possible. But that's a really key point to remember. And also that some of the answers, some of the questions that we may suggest in our conversation today, those answers may be found in 21-year-old federal guidance. They may be found in places other than the 560-page final rule. And that's how the law is. This does not repeal any other laws, any other statutes. It changes the regulations from 4 years ago, but it doesn't change any other statutes. So if I have a specific right under the Rehabilitation Act of 1973, you have to make sure you're compliant with it. That's in addition to whatever the Affordable Care Act new regulations say. I know that can sound overwhelming, but frankly, that's what the law is. There are all these interconnections that explain, expand upon, and answer questions that are needed for compliance.
Yeah, that's a really important consideration. But next, I'd like to bring up 2 very much interconnected topics. And they are Section 1515.7 coordinator and training. Obviously, appointing someone for the position of coordinator is the first step, or maybe the training could be the first step. Chicken or the egg dilemma. But nevertheless, training is a must. And I will turn it over to you to talk more about qualifications, filling the position, and training.
Yeah, I completely agree with you. I think training is a must. It's been recognized by the Department of Justice for years. Not enough organizations have effective training, we'll put it that way. Some organizations do the 15, 20-minute onboarding and talk about some of these laws generally, and they don't really do follow-ups. And as I said, I teach in medical school. I talk to my students about these issues, other faculty, and leadership. Medical schools typically don't address these issues. Continuing medical education typically does not address these issues. Companion leadership training for healthcare typically does not address them. So where do you find people who have the knowledge? It is a significant responsibility because they're your front person for compliance. But when I was asked a few years ago by a longtime client about this, the very question that you asked, Jen, where do we find these coordinators and how do we train them? So we trained them, and we did that for several years where we would go into all kinds of scenarios and possibilities and when can we use VRI, and what if it's not working? What should we do, for example? So this cannot be taken lightly because as we talked about, the coordinator is required now in law for the first time ever. And HHS is expecting, because of the way the final rule is written, that this coordinator will coordinate training, be responsible for training, attendance will be mandatory. And if there is a compliance review or hopefully not some enforcement action, it'll be one of the first questions that you're asked, guarantee it. Who is the coordinator? Show us an example of your training. It's at the top of the Fed's checklist. They always ask these questions. I guarantee you that they will ask you with an informal inquiry or as that gets ratcheted up the ladder. So if I were a healthcare CEO or in leadership, I would, when I was interviewing, if I were interviewing people, I would ask them specific questions from the rule. What does this mean? What is your experience working with the Rehabilitation Act? What can you tell me about website accessibility? All of these issues are involved inextricably from the position of coordinator. And it's not like HHS trains coordinators. They don't do. I know at the DOJ, we were often asked if we could train staff and train the equivalent of a coordinator. And our very politic response was, we're in enforcement. We can answer questions for you, but you have to figure it out yourself. And sometimes people did, sometimes people didn't. So it is really important that your coordinator is your in-house expert in these areas, because that's what the final regulations say.
Well, and with that, I do have 2 points to make. First of all, I've noticed that language industry itself has been a very fruitful ground for finding capable and well-informed coordinators, language access people, because that's what language industry does. We work on language access. So just as a suggestion for anyone who is looking for a Section 1557 coordinator, look at the language industry. And if you have any questions, feel free to reach out. The second point is tied to training. Also, a recommendation to lean on your language access companies. If you work with someone or a company rather, lean on them for training, because that's in everybody's best interest to do training on best practices, on how to work with interpreters and translators, how to use VRI, and so on and so forth, on cultural awareness, on understanding deaf culture. Lean on your on organizations that you work with in the language space. And if you don't, reach out to us. We're happy to field your questions and support your needs in that sense. But robust, ongoing, repeating training is a necessity. And it's also what makes things work so much better, right, Bruce?
Oh, yes, I can tell you, no question, that the places that I've either investigated or served as their counsel that are the best suited, best situated for compliance have really good training and leadership support. But that really good training is admittedly in the eye of the beholder. I've seen a lot of training that I would not call effective. So as we talked about, the training really has to be in depth. It's not something, it's not a throwaway. It's not something, we onboard people. Not anymore. The training has to be comprehensive and really get to the issue, all the issues that we're talking about. And a lot of the issues we're not going to be able to cover today. But yeah, there's a new world in the healthcare civil rights. And there are areas of the new rules that we're not going to be talking about because they're not really involved with language access that are also very significant and very important. So understanding that and making sure your employees, contractors, and all personnel are understanding is something that the feds want to see. And now the training is included for the first time in law. You bet they're going to want to see it because now they have the perfect question. How are you complying with the law requiring training?
Yes, very true. And by the way, Bruce, we do have a lot of questions in Q&A. So just for those asking those questions, we are allocating about 10 to 15 minutes to answer them. So we will get through as much as we can today, and please feel free to reach out to us afterwards if we happen not to have enough time to answer your question. With that, let's move on to the next topic, and that's translation. What's new with regards to translation in the final ruling?
Well, I'm glad you asked that.
Yes.
Because that's something that also is not really being addressed in commentary that I've read, or if it is addressed, it's addressed incorrectly. There's a lot in the rules that HHS decided to do because of their experience during the pandemic with what they saw as far as compliance by healthcare organizations. This is likely one of those areas. And what I mean by that is that it is current law, not including the final rule, because it's not final law for another 6 weeks. It's current law based on guidance given by HHS, Justice, the Department of Education, for example, that any document that you translate through machine translation must be reviewed for accuracy by a qualified human translator. All right, makes sense. We know that machine translations can be problematic. They cannot always be as accurate as you expect them to be or as accurate as they need to be. Having a human being review what the machine is doing is significant and something that the feds expect. Not anymore in healthcare. So what HHS did, in a way, they are giving covered entities under the final rule a break, saying basically you don't have to have a human being review every translation that your machines do. Instead, they limited the number of materials to those that are most important, that have complex language, that are critical to a patient, let's say, accessing federally subsidized healthcare. That's a big change. So that instead of having to you have a qualified translator for everything, it's just the most important, most critical. Now, what's interesting too about that is HHS doesn't give you a list that explains that. And that's part of why, as I said earlier, you can get some pretty good clues about what that means by looking at past guidance, which hasn't been repealed. It still is good. The original guidance from 21 years ago, for example. And if you read the final rule as a whole, which as good lawyers know, we're supposed to do that. to give the final rule the full weight of it, the intentions of the rulemaker here at HHS. So I'm pretty confident that the answers are there. And maybe that's part of my late night perusal of all kinds of documents. But that's a big change. That's not something DOJ hasn't done that. Neither has education. So I think that, as I said, HHS is saying, we want you to prioritize your most important documents. We don't care if you don't have a human being translate things that are not as important, like, let's say directions to the parking lot, just as an aside. That does not have to be reviewed by a qualified translator. But a informed consent, you betcha, that has to be reviewed by a qualified translator. So that's a big change. You're right, Jinny. It's very distinct among federal regulations and something that will take some time for recipients of federal funding to understand. HHS said they'd put out additional guidance on aspects of the final rule. Don't expect that to happen anytime soon, like this year, for example.
Right.
That will take even more time. So in the meantime, you need to start figuring out what that means so you can be ready for not only when the final rule becomes law, but by the the compliance dates that were set, I think 10 months or 12 months from July, to give everybody time to be in compliance so that when the bell rings in 2025, everybody knows what they're doing. And easy peasy, everyone's in compliance. We're done. No need to investigate because you're cool. So
I hope
that's
it's
a great,
gonna be-
yeah, it's a
I
good,
hope it's going to be that easy.
yeah, I do too. But I don't even think being cynical is an answer here. We know that's not going to happen, but everyone will have a lot of time. So the excuse that we didn't have time to do this is not going to work.
Well, in my mind, my immediate reaction to this new inclusion in the final ruling is that on one hand, HHS recognizes AI and machine translation as viable tools, which the language industry has been utilizing appropriately for the most part for years. And it is a viable and important tool in our arsenal as language professionals. The flip side of it is that the interpretation of what needs to be reviewed, what is vital, is open for interpretation. So that may be a challenge, and I do hope that there is going to be more information on that moving forward. And maybe
I
this is
agree.
something that we can talk more in depth at a separate webinar, because it could be a really big conversation on its own.
Yeah, but perhaps we can, as I agree that it's a big issue. It's going to leave a lot of people wondering, what do we have to do? However, I think that with the appropriate counsel and the appropriate assistance of language access collaborators, supporters, companies, you can figure it out. But it's not as easy. On page 35, there's a list. That's not true. But it is something that is solvable. And while we are awaiting additional guidance, which, as I said, will take a while. And think about what you said earlier. If it took 2 years for the final rule to be published, that kind of gives you a sense of how things work as far as speed in the federal government. Like publication in the Federal Register makes something final. I did some of that work at Justice. It's not as easy as it may suggest, because there's a queue of agencies with things they want to publish. So it's not like I call the Federal Register today and then in half an hour they publish what I want. It doesn't work like that.
No, it takes time.
Yeah.
So let's move on to the next topic, and I'd like to talk about companion piece, because that is definitely new and something that we have not seen before, because it really expands. Well, let me turn it over to you to tell the legal part of the story.
Yeah, I agree. I think it expands significantly the number of people who are either in the room or on the floor who now must be given an interpreter. There was no requirement previously for spoken language companions who are LEP to be given an interpreter. That's going to take some doing as far as education of staff. I mean, there's still staff who don't always provide interpreters or know how to contact an interpreter. Now they'll have to be told, well, the companion defined in the way kind of that we talked about earlier, they get an interpreter. So there has to be some significant re-education just on that point. I agree with you. It is a big expansion. If you look at with what's true with the ADA and having companions have the legal right to an interpreter, that doesn't always happen. There are a lot of cases that I've seen and been involved with where the provider says, wait a minute, you're not the patient. I'm not giving you an interpreter. That's illegal. And if they were involved in litigation, if that were an issue of discrimination, that's a pretty easy one to prove. You either give an interpreter or you don't. So I agree, it's one of the big changes. It is an expansion. Where it leads, obviously, we're not really sure now, other than it will be the law on July 5th for the first time ever. That has never happened before.
Yeah, yeah, that's a big expansion, and we'll see how that's gonna take shape. Um, Two more topics I'd love to dive into before we switch to Q&A, and one is telehealth, of course, because telehealth was not included previously. And well, I mean, the initial iteration was published before and went into effect before COVID. And COVID changed a lot of things with regards to remote work, including telehealth. So what are your thoughts on that?
Yeah, that's a great point. I think this is one of the many aspects of the final rule, which is a direct result of what happened during the pandemic, where HHS found and found through reviewing a lot of complaints and taking enforcement that telehealth was not accessible to people with disabilities and to people who are limited English proficient. So as I said, there was a lot of pushback that telehealth, where show me the word, it's not there. So I know that through my own sources, I know that was frustrating and was not resolved easily, put it that way. So the final rule, HHS decided we're not going through that again. It's the law. So the telehealth, as I said, if it's used within federally subsidized facilities, entities, organizations, if the telehealth provider is federally funded in some way, 1557 covers that, which means interpreters, language assistants, translations as needed, so that if there's a discussion online about informed consent or discharge instructions, then perhaps providing a printed version of that to the interpreter so the interpreter can review it and be able to even more effectively explain it. That must be done now through telehealth. There is no question that telehealth is covered by federal law's healthcare civil rights requirements.
That's great. And in my mind, that's also going to help with reimbursement.
Yes, I think so. And that's something that others will be handling. But I agree with you. I think that it could be helpful in that area too.
So last topic, before we switch to Q&A would be let's dive into clinical algorithms and what that means. I know this is a topic that you are very passionate about. We've talked about it a lot, and now it is clearly included.
Well, administration, more so than its predecessors, has been very committed to addressing healthcare equity and healthcare disparity. Well, one of the aspects of healthcare disparities is if you are starting from the point of diagnosis, for example, if you're starting from the standpoint of taking patients' vital signs right at the outset, if you're taking like a pulse oximeter, for example, measuring the oxygenation of blood, if your readings are different for someone who looks like me and someone who has darker skin color than I do, if the readings are different just because of skin color, you already at the start have a discriminatory effect and result. The pulse oximeter readings showing this distinction between dark skinned people and lighter skinned people has been known in healthcare for more than 40 years. When I mention this to my students, the healthcare students, the medical students are horrified. And they have very powerful reactions. How could this have happened? This is awful. I'm going to find an alternative to that. With my law students, I ask them a very simple question. Is using something that you know is discriminatory for 40 years, does that mean that that proves the existence of intentional discrimination? And, they're kind of hesitating a little bit. But there are always a few students who say, and I agree with that. I think that this is going to be a new area of healthcare liability that really hasn't been addressed yet. And it will start to really get at healthcare disparities because you have to treat everyone the same way. If you know that your algorithms are flawed, and I'll close with an example that you and I know very well, then don't use them. Talk to the manufacturer. Use an alternative. Invent something or have someone at your facility invent something. And I think that you're right. This is something I'm very passionate about because it really gets me going in a lot of ways. But I'll harken back to something that happened last year in Allegheny County, Pennsylvania, which is where Pittsburgh is. The health department used a computer-generated, computer-driven algorithm or device or program to determine whether or not foster parents were entitled to keep their foster children in the event something happened. Well, there was an allegation against two parents who had disabilities. I think they had physical mobility disabilities. When they came in for their usual check with the department, they were told by an employee, the computer told me to take your children away. Now, this is a program that is known to have problems, but can you, as a parent, I can't even imagine that. I keep reading that article, Jen, because it is so illustrative of what we're talking about, but just pulled my heart out of my chest because of what happened to the parents. As a result of that, the Department of Justice started an investigation, got a lot of media attention. I don't know that the department has released any findings or they came up with an enforcement agreement. But that's one of the big reasons why this new part of the rule is so important. If it discriminates against protected categories, don't use it. If you can't fix it, get an alternative. Period.
Absolutely. Yes, passionate and rightfully so. Before we switch to Q&A, and I'm gonna have Leah start on that in just a minute, I wanted to see if we can do the last poll question with regards to what our audience thinks the biggest challenges might be for them in implementing the updated section 1557. Thank you. The answers are coming in. We'll give it another 30, 40 seconds. Well, the answers are different. But one is emerging as a clear top answer. Okay. Thank you for answering. All right, I think we are at a point where we can stop. And yes, as you can see, the results are are in, and 45% of the people answering cite lack of expertise as their biggest challenge. Well, if you have any questions, please feel free to reach out. This is a really big deal, and if we can help you to gain that expertise, we would be glad to do so. And with that, let's work on Q&A. Let's see what the questions are.
Awesome. Bruce, Jinny, thank you. That was some incredible information, and we have a lot of great questions for the two of you. So let's go ahead and dive right in. Which entities are included under the healthcare category? Does that include home and community-based services under Medicare waivers?
Bruce, you want to take this? I know the answer, but
You go ahead. So you go ahead, Jen.
yes. Every entity that receives federal funding directly and indirectly, including home and community-based services under Medicare waivers, would be, as long as an organization receives federal funding, they would be included.
Yes,
Okay.
absolutely. And the federal funding has to come from HHS or one of HHS's sub-entities to be covered by this rule.
Excellent. Thank you for clarifying that. So then our next one is, what options are available to folks when or if these regulations are not followed?
Well, just like the statute, the Affordable Care Act, there is what's called a private right of action, where patients, or if God forbid there's a tragedy, the surviving family members can sue for discrimination damages. HHS also has significant enforcement authority. The enforcement authority could be extended all the way to suspending federal funding, suspending participation in the Medicare, Medicaid program, and in addition to having HHS essentially establish an office in your facility and staying there for several years. HHS does not need a warrant. They don't need probable cause to do investigations. You remember when you signed up to get Medicare reimbursement? You signed something called a certificate of assurance. In that certificate, you agree to cooperate basically all the way with HHS requests and investigations. So those are examples of how enforcement could occur. There could also be fines and penalties allocated by HHS and or the Justice Department.
Okay, excellent. Thank you. So our next question is, how do you see the new OCR section 1557 interfacing with the Office of Minority Health's national CLAS standards and the Joint Commission's new National Patient Safety Goal and accreditation requirements relating to healthcare equity?
What things that HHS does not do is HHS doesn't opine on private liability and private lawsuits. I learned that years ago from a high official in HHS that we just don't talk about that. We talk about regulatory authority. The class standards were used, for example, in a recent case in New Mexico as an example of the standard of care. So the significance of that is that the standard of care which doctors and hospitals must follow said that you have to provide language services, translations and interpreters, for example. They weren't done in this particular case. So this case argued that, well, you're violating the standards of care because the class standards set the standard of care. So I think the new regulations work very well with the class standards, for example, and align with other efforts in the administration that have been promulgated or put out by HHS on similar issues of health equity and disparities. But you can't overlook, it's not in the rule, it won't be there. There is a substantial private litigation aspect to not using the class standard, to not following the Joint Commission. It's something that a good trial lawyer would love to ask on cross-examination or in a deposition, because then after the question is asked, then you want to have a settlement discussion as soon as possible. Violating the standard of care is bad. And the New Mexico case is a good example of what can be argued successfully with the class standards establishing the floor of what healthcare is required to do to be compliant with standards of care.
I like that you said it's the floor, not the ceiling. Should be the bare minimum of what providers are doing for their patients. So great answer. Okay, so moving on, we'd like to know, what do you see as the impact of these new requirements on small private practice clinical care settings and other resource-constrained health and mental health care providers? And what flexibilities or leniencies, if any, exist?
Whitney, do you want me to do that, or do you want to jump in?
Go ahead, Bruce.
Okay. The rule, for example, we talked a lot about today about Section 1557 coordinators. That's only required if an organization has at least 15 employees. So if you don't have 15 employees, some of these requirements don't apply to you. But don't get all excited thinking you can discriminate against people as much as you want. That is not true. There are, Jinny had talked before about language services companies providing language access and knowing how to make things as effective and efficient as possible, while also having an understanding, if they're good companies, about what the law says. So a good language access company will be very helpful to you if you're a small provider, small practice, in how to comply. And I would add quickly that the final rule includes for the first time Medicare Part B recipients. So if you're a private practice doctor in a small practice, big practice, the odds are you may take Medicare. If you take and that being Medicare Part B, then you are now covered for the first time by the non-discrimination requirements of federal civil rights laws.
And one thing that I would like to add is, from a practical perspective, there are many solutions to deliver meaningful language access. And some of them are much more cost efficient and can be implemented. It's about wanting to be compliant. The solutions will be there. I hate to say it, but we're almost out of time. Maybe we have time for one more question. And I have a suggestion. Maybe we can look at the list of questions that we don't get to answer live today and consider answering them in the next webinar and invite everybody to join us again. So let's do one more question, if you don't mind.
Okay, let's go to this one. Does every doctor's office have to have a coordinator? Let's go back to that, the 1557 coordinator.
If they have at least 15 employees. Now, I would say that the word employee is not legally dispositive here, so that if a doctor's office decides, I don't want to have employees, I want to just have independent contractors or subcontractors, and I have 30 of them, that's not going to work. So it says employees, take that literally, but also understand that if you kind of try to cook the books a little bit so that, well, they're not really employees, they're something else, that won't work. Think of it as you got at least 15 people in the office, you have to comply and have a coordinator. You have 10, you do not.
Okay, excellent. I think that was a good way to wrap everything up. All right. Thank you again so much, Bruce and Jinny, for your insights and for diving into this potentially very complicated subject, breaking it down for us to make it not seem as overwhelming, to make it seem like we have some great strategies on how to implement these issues of compliance. So thank you so much, both of you. And we want to again thank everyone today for attending. And I have put my information a couple times in the chat. If you'd like more information on how you and your organization can be compliant, if you're not sure if you are and you just would like a consultation, that is absolutely something that we can help you with. We are here to be a resource for you and for your organization, so please take advantage of that. You can email me at it's leah@brombergtranslations.com. And I'll be happy to get with you. And if we need to bring Bruce in as our legal expert, we're happy to take advantage of that resource as well. So thank you again, everyone, for coming today. And that will conclude today's webinar.
Thank you. Goodbye.